Good morning, all. Very nice to see you all in the last one of these webinars before the Christmas break. It's looking pretty festive by me. I can still see the snow from the weekend. But for those of you who don't know me, I'm Reeve, a partner in the employment team, and I'm joined today by my colleague Naseem Nabi, also a partner in the team. We thought we would end the year by looking forward to 2023. And we're going to break it down. I'm going to start by looking at some of the legislation that we are likely to see in the coming year. And then Naseem is going to pick up and look at the cost of living crisis and what that means for employers and some of the questions that we've been being asked about that. So moving on. Jess, if you could flip it on to the next one, please. Well, I will. So I'm going to cover, as I said, some of the expected developments. So I'm going to look at 3 different areas. I'm going to look at the impact of us leaving Brexit in terms of the EU law. I'm going to look at statutory code on fire and rehire, which is still on the horizon, and also then some of the developments that we're going to see in family-friendly leave. So starting off with the retained EU law bill. Jess, if you flick it on to the next slide, be great. So we are going to see there is a bill that is currently being through the committee stage of the House of Commons and is now currently about to be debated at the debate stage at the House of Commons, called the EU Law Revocation and Reform Bill. Doesn't sound like a riveting read, but it's an incredibly important bit of legislation. If it's passed, it's obviously still got quite a long way to go through the parliamentary process, and so it's really just a heads up so that you understand what it is people are talking about and understand the implications. We're obviously going to keep a very close eye on this so that we can update you as it goes. Essentially, it is a piece of law which confirms that any law which has been derived from the EU will come to an end at December 2023, unless the government expressly opt it back in again and choose to retain it, or potentially extend the period of time to decide. So it's been called a sunset clause because all the law that we got from Europe would come to an end. And it's really quite significant because that includes all the statutory instruments that we have passed, so the secondary legislation that we've passed in the UK, but that's come out of European directives. So examples of that are the working time regulations, the part-time workers less favourable treatment regulations, the fixed time worker regulations, agency worker regulations. So there was some commentary from some employment lawyers who said that there are 1,000 statutory instruments that we have passed in the UK that derive from European law, that the government plan to look at each and every one before December 2023 and decide whether or not to keep them or not. And if not, they would automatically lapse, and that law would then cease to exist until or unless some further new UK legislation was passed. There was also flexibility in the bill, so that some primary legislation that's being derived from the EU can be amended more easily, so as if it were secondary legislation, so it can give the government more power to enact legislation or to change the European derived legislation without going through the normal scrutiny process. And finally, the sort of third impact of it is the primacy or the supremacy of the European law. So most of you will know that prior to Brexit, court cases that got disputed went all the way up through our system, but then went to the European Court of Justice. But we also had cases from Europe that were considered at the European Court of Justice. Some prime examples are the treatment of sickness during, the treatment of holiday during sickness, those sorts of cases that were determined at ECJ level. And December 23, those cases will cease to have primacy. So our courts, our employment tribunal system would not be bound by those in the same way they are at the moment. So, as I say, we're still we're at early stages, but it's receiving a lot of attention because of its significant impact. It's been much criticised because the government haven't done a detailed analysis. What they haven't worked out is actually what are all the implications of this law. These are all the major principles of it, but what does that mean? They haven't actually, before they've launched the bill, done an analysis or an audit so that they're clear how this is, all the impact this is going to have. And critics of the bill say, well, we shouldn't pass legislation if we don't know what the consequences are going to be. So lots of people consider that it's ill thought out. I think the Employment Lawyers Association that both Naseem and I are members of have been very critical of it because, you know, irrespective of whether or not you agree with the law itself, you know, the working time regulations are incredibly badly drafted. I'd quite like to get rid of bits of them, some of the stupid law. It'd be quite nice to get rid of some of these bad pieces of law. But actually, what creates most problem for employers and our clients is uncertainty. And actually, when you don't know what the law is, that is far harder than understanding what the position is and being able to take an informed view and reaching a decision on that basis. And uncertainty, you know, keeps lawyers in jobs, keeps the courts too busy, really, because that's where litigation occurs, when there's a void or a vacuum in the position. And so it's being criticised on that ground. One of the suggestions that has been put forward, which is that rather than it being automatically everything comes to an end, a sunset, that it's a sunrise, so that essentially the government have got the right to sort of everything remains until and unless they're turned off, so that actually there's not this sort of ticking clock to review everything before December, but in fact they can look at each bit of legislation and you know, change it or repeal it if that's an appropriate thing to do, but that actually hasn't formed part of any of the parliamentary debate. It's just legal commentators who think that flipping it around that way would be a better idea. But as I say, we'll keep an eye on it, and we'll obviously let you know if it changes. But I think in my lifetime, we're used to, my working lifetime, we're used to employment law changing on a really regular basis, with new law being introduced all the time. And it's been a fairly steady state most recently, and over COVID and recently. But actually, this piece of law will be one which unpicks a lot of the legislation we've seen over the last 10 or more years. So interesting to see how it develops. I'm going to move on now to look at the statutory code of practice on fire and rehire. Many of you will have been with us when we talked about this previously. This comes out of an employer's decision to terminate existing contracts of employment and re-engage staff on new terms and conditions of service to essentially affect changes to working practices, terms and conditions to meet the needs of a business. This had been something that had been, you know, used as a tool by employers over a period of time historically, and it had been established as being a potentially lawful reason to bring contracts to an end. It did, however, hit quite a lot of criticism during the pandemic. You'll be aware we saw British Gas or Centrica try and terminate the contracts of a majority of their staff to introduce less favourable pay and overtime rates and other working conditions. And also British Airways, during the height of the pandemic, trying to change its terms and conditions that it employed staff on as well. And so that led to a backlash and private members bill suggesting that this be outlawed, and in fact unions have, you know, recently sort of cottoned on to this and are very anti any suggestion of what they call fire and rehire. So the government did, so the government asked ACAS to look into it. They produced a report, and essentially the government said first of all, they said they weren't going to legislate, they weren't going to prohibit this entirely. Then ACAS produced some guidance, and now then the government said they wanted ACAS to produce a statutory code of practice. So although it's not legislation, it will have legally binding effect, and a tribunal would have regard to it when deciding whether or not a dismissal in these circumstances was fair or not, and failure to take the code into account could uplift compensation by up to 25%. So very similar to the statutory code of practice on disciplinary grievances that most of you will be familiar with. And so tribunals have regard to it, and failure to follow leads to that increase in compensation. Well, we expected the code in November 2022, but it hasn't arrived. The government say that it will be published in the near future. So we'll keep an eye out on that, but you will also be aware that it's happening. And so it will be particularly relevant where you're looking at collective changes to pay, to other terms and conditions, where you might have to bring contracts to an end if you can't reach agreement at the end of the process. But it might also impact just on single or very small restructurings that you're doing in an organisation as well, that you'll need to think about. We don't expect the Code of Practice to contain anything sort of groundbreaking or different from what you're used to following in terms of a fair process, in terms of consultation, but actually it's, again, makes it more difficult, I think, potentially to follow these processes, and it's very clear that it should be a last resort, which probably makes it more difficult than it had been historically to establish a lawful reason to bring contracts to an end in these circumstances. My final slot today, just flick on, is around changes we're likely to see in the area of family leave. So we're not likely to see huge amounts of employment law change, but actually, and we were quite surprised that we didn't hear anything in the last Queen's speech, or so nothing's on the horizon, and the employment bill that was promised seems to have faded away, really. So what we have seen instead is that private members' bills are coming through that have gained cross-parliamentary support and have then been backed by the government. And so these are the ones that are non-contentious, that everybody supports, and that therefore are likely to become law. They're all when parliamentary time allows, but we think we'll see them probably certainly in 2023. So the first one that I wanted to mention was the additional protection from redundancy for pregnant workers. So there was a study carried out by the Equality and Human Rights Commission that found that 77% of women felt that they had been treated detrimentally or less favourably because they'd been pregnant, because of their pregnancy, by employers. And there was a commitment to try and correct this. The recommendation was that we look at the existing protection that's in place and look at extending that. So most of you will be familiar with the special protection that pregnant employees have. So at the moment, you're protected from being subjected to any less favourable treatment as a result of being pregnant or taking maternity leave, but also you have particular protection from redundancy. If you're on maternity leave, you can't then be made redundant if there is an alternative position. So pregnant women get this priority treatment. If they are pregnant and there's a suitable alternative, they must be offered that rather than redundancy. Now, this sort of protective bubble applies only when they're on maternity leave at the moment. So it's still, they don't have that additional protection. They aren't entitled to the prioritisation in alternatives if they're pregnant but before they go on maternity leave, or when they come back from maternity leave and they've returned to work. And so often that meant that employers could defer redundancy programmes to avoid that period of time. So the government are simply proposing that they're going to extend that protection. So the right to have priority over that suitable alternative role will start from when they notify an employer of their pregnancy and will end 6 months after they've returned to work from maternity leave. So it'll be an extended period. So when the law comes in, if you're carrying out redundancy processes, at the moment you need to consider, have we got anybody who's on maternity leave? How does that impact on the alternative jobs that we've got? You will need to also consider anybody who's notified you of their pregnancy and who's returned from maternity leave when you're considering and planning out the impact of a redundancy process as well. The second bit of family protection that we're going to see is the neonatal care and leave bill, which gives an additional protection of up to 12 weeks paid at the leave and potentially paid at the statutory flat rate of statutory maternity pay as it is at the moment, on top of current statutory maternity pay and leave or paternity pay and leave for people whose children are born prematurely and need to go to intensive care for at least 7 days in the first 28 days of their life. So if they've got children, a baby who's born early and needs neonatal care, then they get this up to an additional 12 weeks pay. So their maximum leave would be 15 months, so that they would have their 12 months maternity plus the 3 months neonatal care as well, and to give additional protection for those very early days. So we're likely to see that change coming in. So it will be a day one wide, so everybody will be entitled to the leave, but you need to have 26 weeks service in order to get the pay. And again, it's at the statutory flat rate. And the final thing on this slide is carers leave. And again, this is another non-contentious change that we're likely to see, which is essentially a week of unpaid leave a year for anybody who requests it for the purpose of caring responsibilities. Although it's obviously important and going to meet a need, I think like many of the other unpaid leave rights that we see, it may be that we don't see much take up because people are unable to choose to take a week off, but they will have that ability to do that should they wish. And it could be a useful tool for you to think about where you're managing individuals who have got challenging circumstances and need to take a bit of time. They'll have the right to that careless leave. So I think we will see an extension of all of these things over 2023, and you'll obviously, we'll keep you updated, but you'll just need to update and reflect your policies to keep these changes, keep up to date with these changes. The final thing I wanted to mention before handing over to Naseem in 2023 is flexible working, which we saw just as we were prepping the slides, that there is again support for a private members bill to reform flexible working, which again would make it a day one right, which would require changes such as consultation and to look at alternatives before turning down a request. So we'll definitely see that change to flexible working regime fairly early in 2023, I think, as well. And so that's a topic that's really interesting, particularly when looking at sort of working from home and hybrid working as well, and the change that we've seen in expectations following on from the pandemic. So we'll definitely be running some sessions, at least one session on that as we move into the new year. Thanks. Obviously happy to take questions at the end, but I'll hand over to Naseem now.
Thanks, Alice, and morning all. Over the next few slides, what I want to look at is the cost of living crisis. It's something we can't ignore. And we, as a firm, have looked at, well, what are employers considering? What might the options be? So this morning's piece is really just a thought piece, just for you to take away and think about, well, what could you possibly do in your organisation, in your business, to see how you might be able to support colleagues. Now, it goes without saying this year has been dominated by the cost of living crisis. So inflation's running at double digits, and it's just really is outpacing wage growth. So it's meaning a real term reduction in income. So this morning we've seen a small fall in the rate of inflation down to 10.7%. So that's from October's high of 11.1, but still higher than September at 10.1. So how might employers better support or best support staff in times such as these? So as I say, the aim over the next few slides is really just to share the thoughts that we've collated, that we have heard other businesses talk about, and options that we know that are being considered across sectors. So there's no one size fits all by any means, and there's no right or wrong approach, I'd say. It's all about what can you as an organisation achieve in these times, and whether there are any one-off initiatives that you might want to consider, as opposed to being stuck with any sort of pay award that might then outlive any increase in inflation or any reduction in inflation as that might come. The simplest answer to all this might always be, well, what financial support can you offer? What can be considered in respect of pay awards, should they be made? Going back to that basic question, what can you afford? And affordability is something that can be taken into account by businesses and must be taken into account. trade unions at the moment, with the debates with government, are looking at saying, well, affordability shouldn't be the only aspect you're looking at, and absolutely not. Recruitment and retention is part of that. But if you can't continue to afford any increase that you might award, then are you putting yourself in a really difficult position? Organisations and sectors are really struggling with budgets. So whilst we'll look at that financial support, as I say, please don't consider that this means that it must be suitable for all. Now, if you are looking at pay, can you be selective in how you apply it? So whilst we're all struggling, it's largely those that are going to be on the lower incomes, or indeed those who are on middle incomes as well, who might not be able to continue to afford mortgage payments, etc., going forward. But could you perhaps look at any sort of tapering provision? So, for example, for those who are in those lower paid roles, might they be the ones receiving the higher percentage rises and then taper as you go up, rather than perhaps having an artificial threshold over which you then wouldn't apply any pay award, and that could avoid then any disappointment for those that might just be above that threshold if you did choose to apply one. So that tapering we're seeing mentioned quite a lot at the moment. We've heard of others that are choosing to adopt more frequent pay rises. So rather than your one high percentage or higher percentage rise at the beginning of your financial year, can you look at perhaps offering a lower rise, but then including a mid-year pay award? Could that be another option? Might that spread the burden for yourselves, but also then stagger the pay award for colleagues, and they might prefer to receive it in that way? Might not work for you, might not be feasible for those who are on the lower pay, but it's perhaps worth a paper exercise just to chart its impact, and also just to look at whether or not it is even a starting point for you. Perhaps unlike traditional pay awards, inflation, it is a moving target. So my worry always is that if that target, as we've seen, is likely or projected to fall, awarding a pay award which then is inflation plus could then leave you in a difficult position. And in these turbulent times, we don't want anything that's going to potentially have longevity and potentially leave you in a position where you can't then claw back any pay award that's already been made. So are there other ways in which you can achieve that? So what else are sectors considering? Salary advances, they are sometimes being considered. Might they be difficult? What might the terms of those salary advances be? And would you have to look at repayment if somebody were to then leave your employ? What then if you'd already made an advance payment? So there, again, it's not an easy decision, but we have to look at how might we be able to better support those who might need immediate support now. So existing bonus and reward schemes, I think they can often be overlooked, perhaps not used to their biggest potential and their fullest potential. So if you offer those schemes, how do you promote them to colleagues? Are colleagues regularly reminded of what you do have and what those rewards can look like? And is it worth reviewing, if you haven't already, what you do have? Other payments that we are seeing being made are the one-off cost of living payments. Could that be considered? But it would have to be, a one-off payment, and being absolutely clear that it's a one-off payment, but you'd have to be mindful of what unintentional adverse impact they could have, particularly those who are in receipt of tax credits, because it might take them above those thresholds. So it might impact whether or not they qualify for tax credits going forward. Now, I don't want you to take on the burden of making sure whether or not someone meets the relevant criteria, but it's more a case of alerting colleagues to the fact that these one-off payments could have an adverse impact. So they do want to be mindful of checking their own personal circumstances. But those one-off payments can help, and it then also avoids putting you in a position where you have increased somebody's pay year on year. It's very much just that, a one-off payment. So moving on then, let's have a look at what other suggestions. but these still require further thought. But I thought it's worthwhile you going away with them, knowing what you would have to look at. Because look, if we are going to treat staff in different ways, then again, there are unintended consequences, perhaps. Allegations of discrimination, for example. Are we treating colleagues more favourably than others, and what might their circumstances be? Might we be looking at part-time workers and how are we impacting them? Might there be allegations of discrimination, sex discrimination, for example? So what might you do if you have colleagues who are then on family leave, maternity leave, or some sort of sickness absence? So they might earn above the threshold whilst they are there working, but no sooner are they off, they might then not. So what are those criteria? What would the criteria that you would then set out and suggest? And again, conditions of one-off payments. Now, these are keen, I'd say. Quite often we're asked, can we provide one-off payments to support with training of staff? And then we have a look at whether or not that those training costs are recouped if somebody then leaves, or might it then have to be paid back on a tapering amount depending on when they leave. I think those sorts of similar repayment schemes can be considered here. What might the condition and conditionality be around those one-off payments that you seek to make? And might you even exclude individuals from qualifying to ask for that payment? So for those, for example, if they were within their period of notice, for example, might you then choose to say, well, it doesn't apply to you? Because there's always the worry about having to claw back repayments, or are you then going to be faced with litigation and having to chase those repayments, which in themselves are hugely costly? So we don't want to add to the extra burden of costs. It's also worth noting, particularly in the climate that we are talking about, that we are surrounded by industrial action. You only have to flick on the news and you'll see that throughout this month, there is an industrial action of some shape or form happening every single day, all the way through to the new year. So if you are an organisation that recognises trade unions, or where you might have an employee representative group, for example, then you must consider, if you are looking at any sort of change that might impact collective terms and conditions and pay and benefits, that you first engage with those recognised unions and groups, because we don't want any sort of consequences where we potentially could be seen as undermining or circumventing existing collective agreements and that machinery that's there to protect those members. So do be mindful of that, because whilst you might have the best will in the world, we can potentially have pushback from unions if it could be seen to be undermining those collective agreements that are already in place. Moving on then, I want to look at other flexibility that could be offered, and that's flexibility through benefits. Again, not one to be underestimated, because many employers offer just a huge variety of benefits. And before coming on, I thought, let's have a look to see what we offer at VWV. And on the intranet splash page, it does set out all sorts of benefits, from discounts for haircuts or discounts for gym memberships, all sorts. And you too might have a collective group of benefits, be they small or be they organisation-wide. So it's worth really understanding, what do we have that might be seen as an additional benefit that might help in these circumstances, and how might we go about promoting those? Now, starting slightly bigger, so those salary sacrifice schemes that are quite often offered by yourselves as employers, they're a real good example of flexibility, and it also gives the individual the choice of the benefit that best matches their needs at any particular time. So be that childcare vouchers, be that pensions, cycle to work schemes, laptop schemes, healthcare schemes, gym memberships, whatever they might be. I'm sure you've got a variety there that you could pull together and collate your benefits, so that we are just better skilled and better adapted at making sure that staff are really, really aware of what is there on offer for them. And are there any subsidy schemes? So do you subsidise, for example, transport, free meals at work, refreshments, I mentioned the gym memberships, but any other sort of corporate discount or loyalty schemes that you might offer, it's definitely worth putting together. We are seeing sectors using flexibility through pensions. So staff are seeking to perhaps reduce their pension contributions in order to take more cash now. Now, whilst those sorts of pension schemes that do operate salary sacrifice can be useful and can mean that somebody can use more cash now, albeit they are reducing their savings for the future, it is helpful, yes, for the immediate crisis that they might find themselves in. But I don't think we should underestimate the whole benefit of saving for the future. Again, easy for us to sit here and say that we should be looking to the future and not just immediately responding to the crisis at hand. But you know, the auto-enrolment legislation was brought in to ensure that there are minimum protections, minimum employee-employer contributions that are being made. And I think that objective shouldn't be forgotten, because you don't want somebody potentially leaning on their pension scheme when that should be for something for the future. But if there is flexibility there that can be afforded, then making sure that you can signpost colleagues to receive the advice that they need, so that you're not providing the advice, because it is financial advice and you don't want to be in a position where you are providing advice which might be a regulated activity when it comes to financial advice. So do make sure that you can signpost, be that through your own pension provider, so that they can talk specifically about their scheme, or if you can signpost to external third parties that might be free of charge, or you might be prepared to look at absorbing some of the costs in obtaining that information for them and allowing them access to a financial advisor. What else are we seeing? Interest-free loans is another that we are seeing talked of and mentioned. And is that something that you can do to alleviate hardship and unexpected costs? Again, you can have qualification criteria around that. Now, with interest-free loans, they're unlikely to then fall within Consumer Credit Act advice, but nevertheless, just be mindful that where you are talking about loans, it potentially can fall within that Consumer Credit Act zone. So you don't want to be providing advice or providing loans. So do make sure that you're taking advice before you do anything, so you can make sure that it is a loan that you are able to provide. Hardship funds, I suppose, is the other one that we're seeing being mentioned and being used more and more at the moment. Is that a scheme that you already have in place? How is that hardship fund built up? Would you consider putting one in place? What, again, might the parameters be? A lot of what we've mentioned so far, what I've mentioned, is talking about understanding what will parameters be whenever we offer something that might be over and above ordinary pay rises. And that is sensible thing to start with, just to understand what might qualifying criteria be, how might we claw back money, are we prepared to claw it back, will we accept that we are making one-off payments that shan't be clawed back, so how will they be labelled? So whether that's hardship, whether it is salary advancements, whether it is pay awards one-off or annual, or mid-year. So just be mindful, plan it out to understand what you can do and what you are prepared to do. Another that we're hearing being mentioned is buying back of holiday. So, you know, we are seeing some employers that might consider that, or even considering whether employee to employee can buy a holiday back. But just be mindful that an individual is entitled to 5.6 weeks paid leave, so that aspect can't be paid in lieu of, unless you're looking at a termination of employment. So it's not that 5.6 weeks that we're going to play with, it's anything over and above that. Might there be scope there? Now, again, it all comes down to the sector that you're in, whether that is achievable or not. But these are the sorts of things we're hearing clients and organisations talk about. Moving on then, please. What else? What else can you possibly do? We've heard many employers say, well, we've got an employee who would like to take on a second job, but our contracts don't permit it. It does say that they're prohibited from working elsewhere whilst they're in our employ. What can we do about that? Is there any leeway there? Yes, you can put in flexibility for an individual to take on a second role. You'd want to make sure it's not in a competitive role, but if they had the flexibility and they wanted to use that flexibility to gain some extra income, then yes, you could. There are aspects that you'd want to be mindful of. So you don't want somebody who would take on another role that might then adversely impact the reputation of your organisation or impact the work that they do for you. So we have to also look out for the general health and safety of the individuals. So are they working excessive hours and prolonged hours? Have they opted out of the 48-hour working week with you? So there are aspects and controls that you'd want to put around that, but it's not a simple no all the time. It's just understanding, could there be a degree of flexibility? How long might that flexibility last? Location is another one. So Alice and I are both working from home today. That might be through choice because quite often the Wi-Fi is unstable at work, but nevertheless, if colleagues are saying, I've got a genuine reason that I would like to work from home because I don't have the travel costs, that's one reason. Or it might be quite the opposite. I want to come into work because then I don't have the overheads at home. So what can you do? Can you look at personal circumstances? Can you make adjustments so colleagues are avoiding additional expensive outlay? Is that possible? Now, it all comes down to your sector. I completely appreciate that. It might not be possible, and they might need to have face-to-face delivery of services, for example. But where flexibility is permitted, then do make sure you can apply that flexibility and you are reviewing that flexibility, because quite often we are pressed on, well, now has it become custom and practice, for example? So am I obliged now to continue with this? So you can always ensure that what you want to achieve for your business is best for the business, but it's making sure that where you do have flexibility, you're applying it, you're reviewing it, you're monitoring it, and you are reporting back to members of staff on how it's working or not, so that you're continually adjusting to make sure it is the best outcomes for your business as well. But look, all these sorts of smaller things, they do go a long way to supporting colleagues. And if we can reduce costs at all, then it's a good time to do that. Working shorter weeks, working condensed weeks, these are all options that could be considered. Even overtime could be considered. Now, I'd say if there is overtime, how are you going to provide that? Is that going to be a sustained overtime, which we then might have to look at using in our calculation for holiday? So, or is it just going to be ad hoc overtime? Whatever you are going to do, take advice just to make sure what any ramifications of it might be, because whilst you're trying to help colleagues, we don't want it to have any adverse impact for yourselves that hasn't been calculated. So moving on, I just wanted to look at other support that could be offered. Now, VWV were very good at championing things, and we will have individuals that will take on that mantle to champion things. So whether that's well-being championing or all sorts. But more and more we're hearing talk of a financial well-being champions. What are they? How might they be able to help? Would you be prepared to have a group of individuals who voluntarily came forward, who said, I would be prepared to be trained up to understand how I might best support colleagues, how I might best signpost them to certain information. Now, we don't want them to feel as though they have to be the hub of all knowledge, but signposting is key when you're a champion. It's understanding where to turn to for advice, for free advice, and how they might then support the individuals who might be coming to them. But anxiety levels, they are very much creeping up, and they can't be ignored at this time of year, even more so when the outlay is so much more. So what are the additional measures that we can go to support colleagues? And as I say, it's all about ensuring credible resources, I'd say, that you're looking at, which absolutely are impartial and, if possible, are free as well. Now, I mentioned that it's anxiety levels are creeping up. Mental health first aiders, I think, are definitely ones that you could also be looking at introducing if you haven't already, because they too will really come into their own when you're working together as that team. So whether you've got a financial wellbeing champion then teamed up with a mental health champion as well. So it's just providing that rounded support for your employees who may well be struggling. Pension planning, whilst I've mentioned pension planning, that annual pension health check, many an employer provides that, and I'm sure you all do. But if you don't, could you be looking at providing that, or using resources or signposting to resources where an individual could do that, rather than dipping into their pension pot without knowing or really having the full oversight as to what the ramifications might be. Now, before I do sign off, there are some resources that I do want to point you in the direction of, and when we come to share these slides, I'll make sure that they are on there, because I do think they are really, really helpful. So the likes of Citizens Advice, we're all aware of, Money Health and Money Advice online. So these are all financial resources that are free online. A lot of them are driven by government incentives and objectives. Help for household support, for example, that's a government help for households where cost of living support is made available and people can see their eligibility criteria. Money saving experts, national debt advice lines. So these are all resources that you could make available in a discreet manner where people want to, so they know where they can turn to, but discretion too is going to be necessary, as is confidentiality. But in a rounded approach, there are ways here that, with all those slides that we've now had, that you can pick out aspects where you could possibly be helping to support colleagues. Now, when we had the introduction, the final line was about recession and what that might mean for us. Now, I don't want to end the year looking at something like that, but I'm sure in the new year we are going to have to look at efficiency savings, and we will look at that as a separate topic, because I'm sure there's going to be a lot of questions around that. But for now, bring it to a close here, and we're going to now look at any Q&A that you might have. Thank you.
Great, thanks ever so much, Naseem. We've done well for time. We've got 4 questions in the box, but please do please add any questions in, but we'll run through these. The first one is about family leave, which I'll cover, and then there's been some interesting questions around the cost of living point. So the first question was, is the carers leave in addition to parental leave? So a member of staff could have both of those things to care for a child. The answer is yes, it's an additional right. So the carers leave is a week unpaid to look after any dependent family or friend. So that is in addition to what you've already got, which is that emergency time off for dependents, where there is a breakdown of care arrangements, as well as, which is unpaid unless you've got something specific otherwise, as well as then unpaid parental leave as well, time off to look specifically after young children. So there is a suite of available options for parents, and carers leave can be used for children as well. Naseem, I don't know if you had anything you wanted to add on that topic, or we move on to the cost of living questions.
Yeah, I think if we move on, I think you've covered that one, Alice.
Brilliant.
So cost of living, we've got a few questions there. So implications of making crisis loans for staff at low or no interest. Is this allowed as we're a charity? Now, I specifically mentioned no interest because when you start moving into the territory of charging interest, then you do move into consumer credit. So you do have to be really, really careful. And particularly as a charity, you have to be careful as well. What are your objectives as a charity? So you, as a charity, absolutely, you have to be mindful of your charitable objectives and what you're there to achieve. Can you support staff, though, as a charity? I doubt that your charitable objects would preclude you from doing that, but absolutely you'd want to make sure that you are in a position to do that. But my main worry there would be any interest being charged on a loan and what that would mean for you, because you will then dabble into consumer credit. So you'd want to absolutely take advice on that, please. Moving on, can you give staff for whom a one-off payment would make them go over a threshold the option to spread them if they prefer? Now, if there are ways and means that you can avoid somebody falling foul and not then being eligible for any tax credits, then I think that is sensible. That's just making sure that you are best supporting them. So absolutely, if they can find a way in which that they've taken advice, and if they had smaller increments over a period of time, then they would be okay. Then that to me would seem like a sensible spread of support there. So I don't see why that wouldn't be permitted. But do make sure that the burden is with the individual to understand whether or not that threshold is breached. So I love the idea of financial wellbeing champions. Where would you begin to train someone, find the right resources? Well, this one's cropped up a few times now, and I just tapped into search engine last night just to see what might come up. And gosh, the amount of information that has come up, even via ACAS, I was surprised to see so there are lots of resources that you can turn to. So I would say, look, start with the reputable ones, see what government resources are first and foremost that might send you to links elsewhere. But that to me is a sensible starting point. And if ACAS and the like can also do that, then use that. Those money market resources are also really, really sensible. So I think they are the good ones to start with. And the list that I sort of read from before, we'll make sure that we share that with you as well when the slides are sent out to you all, because there's a good sensible list in amongst that.
Thanks, Naseem. Yeah, I think it is an interesting area, and no doubt we will see some really good courses for people who want to take on that role. And then the final question we've got at the moment is about the changes to flexible working and when it's going to come in. It seems to have been on the horizon for ages, doesn't it, this change? We've still not got a start date. I'm really sorry. So we saw just, I think it was only last week, we saw confirmation that essentially it's support for the private members bill, of which this is one of the elements. And so it will be passed into legislation. I think it's probably fairly high up on the parliamentary agenda in terms of employment law, which is still fairly low down in the grand scheme of things. But I'm not sure, we haven't got a start date, but I think we'll probably see it in the first half of the year. Naseem, I don't know if you've got anything to add to that.
I'd be surprised if we didn't, but you know, we've been waiting for this for quite some time. Even the last Queen's speech, it was there and then it was dropped. So anything can happen.
Yeah, so sorry, don't change your policy just yet, but just be aware that it's still the direction of travel. Has anybody got, oh, there's another one just popped in. Great, I was going to encourage any last questions. Oh, thought we'd got through a session without talking about holiday pay. But the final question, have there been any outcomes, developments and updates re the Brazil case? So most of you will have been to at least one session on this, so I'm not going to spend any time recapping, but if people are interested generally, do contact me or Naseem. We've got some free FAQs, and we've got some recorded webinars as well that we'll really have to share as resources, as well as giving more specific advice. But in terms of then the latest developments, no, I think most of our clients are still in the process of auditing, working out which categories of staff are affected. We've seen most people, but not all, kind of correct arrangements where they had not quite reflected the current methodology going forward. We've seen a range of different approaches in relation to arrears, depending on a range of contexts. We have seen, I think it's fair to say, we have seen over the last month, the unions, particularly the NEU, asking questions about schools' approach to it. I've not seen any other unions at the moment pressing that, but particularly asking that question and asking about the approach to arrears. Interesting timing, because for those schools or other clients who corrected it, you know, there's start to be limitation points where it's too late to correct it. So really, I think most clients are still just sort of getting to grips and rolling it out, but we're seeing a bit of scrutiny from the unions. That's that's all I would say. Naseem, is there anything else or anything different you would want to add to that?
No, nothing different. I think that scrutiny point is key, though, because more and more unions are now coming forward, and you can understand that, particularly in a climate where you're trying to get the most you can for your members. So absolutely, we're going to see more probing into it. So we must understand ourselves what our position is and have done our own audits.
Yeah, it does go absolutely to that point, doesn't it, that we're seeing that because there is a financial squeeze on people and they really are suffering, we are absolutely seeing things being challenged and organisations being challenged, particularly where that you might be making decisions where it's impacting potentially low workers or those without guaranteed incomes. And so we're beginning to see sort of things being challenged that perhaps historically might not have been, particularly if they've been corrected going forward. So yeah, it does link absolutely into that topic, doesn't it, in terms of what your approach is.
Agreed.
Any other questions before we close? Well, I'm really glad we had lots of people join us today, which is great. And Naseem and I wish you a very Merry Christmas and hope you have a really restful break. And we look forward to seeing you in 2023.